Thank you. Yeah, this is a pretty exciting day. All of you sitting here today are on the cutting edge. We have a psychedelic renaissance, which the planet needs, and we need. There's a paramount degree of anxiety, depression, PTSD, wars, etc., you all know, and we need to ask ourselves why and rise through it. I want to read you a quote from probably one of the best people I wish I knew, the great father of psychedelic therapy and holotropic breathwork, Stanislav Grof. And for me, that is what this today is all about. And he says, the psychedelic experience has the potential to reveal the interconnectedness of all things and dissolve the illusion of separation. Dissolve the illusion of separation. And that's what psychedelics teaches us, that we are all one with each other and with every cell on every leaf.
We have Steve Bolt, who is a stalwart supporter of drug law reform. He's been speaking at Mardi Gras every year since 1788. And it's really exciting, Steve, that you've come today to also share with us your knowledge to do with the legalities of psychedelic drugs. So thank you, Steve. Come on over.
Yeah. Seeing such a good mob turning up today at this fine sunny morning. Yes, I'm a lawyer. I'd just like to also, before we kick off, acknowledge that we're meeting today on Wild country. Always has been, always will be. They've done, as Michael noted earlier on, done a much better job of looking over than the white fellas have. And I think it's always important to keep that in the back of our minds and in the front of our hearts, that's who we are living among and living with. So all respect to elders and to the mob generally. I'm a lawyer. I'm going to talk about law for an hour or probably a bit less. What I intended to do was just give a bit of a general overview about how the law about drugs and mushrooms, psilocybin, works in very, very general terms. I'm not sure on an admin question if we have a roving mic. These guys, we do. Excellent, excellent. Excellent, very, very good. Oh, sorry, yes, that sounds much better for me too. Excellent, I can hear now. This is a fantastic room. I've noticed, I have been speaking this location many, many times. It's a fantastic room, but the acoustics are shit. So if I don't hold the microphone close enough to my mouth, you can't hear me. If you don't use a microphone, no one else can hear you. So if you want to ask a question, please just grab the roving mic and we'll do that. So I'll, as I say, give a bit of an overview, and then I think just turn it over to questions and answers. You'll no doubt have questions about the legal status and particular situations, perhaps, that we could talk about a bit today. But that's what we'll be doing. Generally speaking, though, to begin with the beginning, there's a law in New South Wales and other Australian states that makes drugs illegal. I know. Anyway, that's been around for quite a while. It's still in place. The Drug Misuse and Trafficking Act is the legislation in New South Wales. That legislation has a schedule, a table of substances that are called prohibited, and depending on the activity involved with the drug, or the quantity of the drug, or the combination of the activity and the quantity involved in the particular drug, determines what kind of criminal offence is being committed. So a lot of this will be common sense. A lot of this will think, oh, that's a bit strange, and you probably want to think it's a bit strange. So the psilocybin is the substance listed in the schedule, in the Drug Misuse and Trafficking schedule, as a prohibited substance. The offences include possession and use of that substance, supplying of that substance, cultivating that substance. If you're in a position to do that, you'd probably be you'd be in possession of the substance rather than active cultivation. Sorry, I'm correcting myself, as the lawyers often do, as we say things. Oh, that's not quite right, I'll correct that. So there's a variety of things, and if there's a large quantity involved in terms of supply, then the offence is considered more serious. Possession offences, not very common really. You see a few of them, but not as many. Of course, cannabis possession offences are overwhelmingly the majority of drug offences that are detected. Methamphetamine possession and supply, much more common these days. Psilocybin mushroom cases, every now and again, it is illegal, but there doesn't seem to be any kind of massive police activity in terms of trying to target mushy users, but nonetheless, it will happen. So if you are in possession of a substance, the law is that the police must prove that you're in possession. Possession is a kind of technical concept in law. So the concept legal possession involves the fact that you have the custody of the substance, of the item, that is, it's in your pocket or in a bag or something like that, or it's under your control in a car that's your car and owned by you and locked and you've got the key and so on and so on. And that you know that it's there and that it's a prohibited drug. So when police speak to people about if they're conducting a search and they find something in your pocket, that's usually pretty good evidence of your possession of that substance, but it's still a very good idea as a general rule not to pause and think about what you say to the police about any admissions you might make. If there's a larger quantity involved and there's some suggestion you might be a supplier of a drug, then in that situation, very much my advice would be not to say anything at all to the police. You're entitled to the right to silence. That is, you don't have to say anything. Give your name and address, that's all you have to do. And you don't have to answer any questions or make any statement or explain anything about where you're coming from. You might get charged anyway, you might end up in court anyway, but the time to have your say is in court after you've talked to a lawyer rather than in a conversation with a police officer on a street somewhere, or in your house somewhere, or in your car somewhere, where everything you say, as they say in the movies, is true, will be recorded and used against you in terms of any admission you might make. All the drug laws have a sort of cut-off point for what's called the deemed supply amount or the trafficable quantity amount. So if you're in possession of a drug over a certain limit, you're considered to be in possession of that drug for the purpose of supply of the drug, unless you can prove that it wasn't for supply. Okay? So I never remember these numbers. One to be falling over and dropping sunglasses, as we do. The trafficable quantity, the deemed supply amount for psilocybin is 0.15 gram of a gram, so almost nothing. So if you're in possession of that quantity, might be for your own use, the defence really is to bring it down to a possession-only offence. If the police can prove possession, then they also have to, or you have to prove that if the possession is there, that it was not for supply, it was just for your own, or something like that, supply for your personal use. Generally, if people are found guilty of possession of a drug, certainly as a first offence, the penalty is often no conviction recorded at all. That is just a finding of guilt and nothing else, or a fine. Jail is really for the more serious activities, I suppose, in terms of supply of larger quantities and so on, but nonetheless, it's certainly an inconvenience and a nuisance. At least have to go to court and worry about what the outcome's going to be. Even if you're a first offender, a good record, a good person in every other way, including in this way, then there's the nuisance value at the very least, and the worry and so on about it all. But the real thing I think the lawyers would say is just get advice about your particular situation. So if you're facing a criminal charge, we can't talk about every possible situation, of course, today. Whether you're guilty or not guilty is really a matter to think about after a charge is laid. Get some advice. There might be a defence. You might be worth running a not guilty case and having it defended in court, or it might be worthwhile just saying you're guilty of that. You get a lower penalty for an early plea of guilty, so that might be in lots of practical ways. If the case is overwhelming against you, you might want to say, you're okay, I'm guilty of that, but look at my good character, and look, I haven't done this before, and I'm a good person, and the magistrate would usually, or would take that into account and would often give you a reasonably lenient penalty. What else was I going to say generally? There was something else, I've forgotten what it is that happens. Louise asked me the other day, just a thing. One of the features of mushroom use is looking for bushies and going into someone's paddock somewhere that might not be your paddock to look for it. So potentially there are legal issues around trespassing. The law around trespassing is the penalty is a small penalty. You can only be fined. There's no jail involved for criminal trespass. So if you go across a fence, go through a gate, if it's clearly, it's a very old-fashioned legislation called the Enclosed Land Act. They would spell it in an old-fashioned way. Been around since 1901, still there. So there has to be a fence or boundary around the property, and if you cross a fence or boundary, so it's enclosed lands, and you don't have the permission of the owner of that property, then you're committing an offence, and the penalty might be a $200 fine or no conviction or something. But there, you could have situations involving people in this room where you might be on someone else's property, and that will be, strictly speaking, an offence. Generally, it's not charged very often. It is charged sometimes, but it's the kind of fairly low risk or low consequence offence, if I could put it that way. I hope that makes sense in terms of the general overview. The real situation in terms of outcomes for criminal charges around drugs or anything else is, in terms of penalty, which is really what in lots of ways we're all about, is the combination of your prior record, who you are, your personal circumstances. First offenders, of course, do better than someone with 15 charges behind them, and the nature of the offence itself. So the possession of a small quantity of a prohibited drug, a small-ish quantity of a prohibited drug, first or second offence, generally will be looked at as a minor offence in the scheme of things, and the things the magistrate would think about would be maybe no conviction, maybe a fine, maybe a good behaviour bond. The risk of jail is zero in those kind of scenarios. The risk of jail comes in when you're involved in larger scale activities, or they were involving larger amounts. Again, finding my chart, anything over 0.25 of a gram, that is, if you're in possession of 0.25 of a gram of psilocybin, then you're likely to go to the district court for the charge to be dealt with there, and rather than the local court, where the penalties can be a bit higher, and jail time comes in. The maximum penalty for that offence and for anything larger quantity is a total of $2,200 in a fine or 15 years in jail. So clearly not so great. In a large commercial quantity, which is more than 100 grams of psilocybin, the penalty is a $550,000 fine maximum and life imprisonment. So we're talking really, really serious charges. But of course they are, I don't know of any case where someone's been charged with the supply of a large commercial quantity of psilocybin. It might have happened, I'm not aware of a case, but that's the max. You can see one hand up. There's one other thing I wanted to say, which I meant to say before, just to put this into some context. There's the way the law works in terms of those quantities and those weights. If a substance is part of another substance, it's the total weight that is taken into account. So here's a simple example. If you're in possession of a cannabis joint and it's got 3/4 tobacco and a bit of weed in it, the total weight includes the tobacco as well. If you're in possession of a cannabis cookie, which might weigh a certain amount of whatever, with flour and chocolate, butter and so on, and a bit of weed in it, it's the total weight of the chocolate and the flour and everything else that's taken into account. For the purposes of what we're thinking about today, largely in terms of mushrooms, the mushroom is the weight. It might have a percentage of psilocybin in it, which is presumably why you'd be interested in having the mushroom in the first place, but it's the weight of the whole mushroom. They don't extract the active ingredient, try to weigh that. So the weights of 0.15 gram, etc., in terms of being considered a supply amount, would be the weight of, if you had 5 or 6 mushrooms on you and they weigh a certain amount, then that's the weight that would be looked at, if that makes sense. Well, in the sense of logic, or whether it's moral or right or not is another thing, but if that makes sense, I hope it does. That's the kind of area I wanted to cover in terms of the general overview. There was one hand I saw already, but if people could just perhaps put your hand up if you want to ask a question or make a comment, and we'll get a microphone to you reasonably efficiently. Yeah, thank you.
Testing, right. Welcome everybody. Hello.
Good morning, thank you for being here. So it sounds like dried mushrooms are better than whole mushrooms because they're way more. I just want to know, as a grassroots community, how can we get the law changed?
Yes, good question.
Yeah. How do you do that?
I mean, is it more than just a petition?
Let's have a drug summit, that might work. I don't know. As a public policy area, the law around illicit drugs has just been beyond infuriating for years and years and years and years and years. All the arguments are clear as. All of the experts think what we're doing is wrong. Everybody knows that. The politicians know that. But for reasons that I can never really understand, politicians are impossible to shift. We've had, I don't know how much they spent on the drug summit the last few days, a few weeks ago in Lismore and other places, had a few local meetings. Don't know how much they spent on it, gathering all the experts together. Before they heard anything, the government said, "Oh, we're not going to change the law. We're not going to change the law about anything. So let's have all this gathering of experts and hear the evidence and talk about it, and then do nothing." So clearly, it's not. The truth doesn't matter. We're apparently living in a post-truth world now. Maybe the fact that it makes no sense to have a law in place around mushroom, psilocybin, LSD and other illicit drugs might be the reason why they do change. So it might be one of those things that changes really quickly. But there's real no sign of change. The very, very minuscule glacial pace of change around things like pill testing, the government might bring in some pill testing, after the drug summit. They certainly haven't said they would, but it's those kind of little bits and pieces of things that get changed now and again, and what we really need, in my view, and probably everyone's going to agree with this, is that the whole thinking about classing some drugs as illegal and some drugs as good and therefore legal is no help to anybody, and certainly is no help to us in a social and community sense. But no, I don't have an answer to change it, but I suppose that's pretty clear. I don't know how to change the law. If I did, we'd be talking about other things today, I reckon.
Okay, question here, Steve.
I was just wondering if the laws that are in, or what they've got in Canberra, is ever going to be integrated into the rest of the country, like in the US and stuff? Yeah.
No. It clearly matters, but all the states and territories are responsible for their own laws around drugs. In the constitutional sense, Australia has some federal laws, of course, and some state laws. There is nothing in the federal constitution that gives the government the power to make laws about drugs, except through the foreign affairs power, because there's treaties and so on about that Australia's part of. So the government could use, federal government could use that authority to say, well, we have the jurisdiction, the right to make laws on the subject of drugs. All they have done, though, is to reproduce the prohibition model in a federal context. So there are federal criminal laws around possession of drugs, importation of drugs, heroin, methamphetamine, cannabis, etc., psilocybin, LSD, that mirror and reflect that prohibition approach. In a practical sense, the police lay charges under the state laws and not the federal law. So the fact that Canberra has had a very successful decriminalisation program in place now for 18 months or thereabouts, I'm not quite sure, it's been going for quite a while, where the approach is that police do not charge people for possession of smallish quantities, they do not ignore larger scale drug offending, as in trafficking and supply, etc., but they just ignore personal quantity amounts. allow a small amount of home cultivation in the cannabis area. That has caused this guy not to fall in the ACT. The review of it last about a month, 5 weeks ago, there was a formal review that said, police said, well, we haven't noticed any difference, this is all good, we like it, no troubles. There hasn't been an outbreak of antisocial behaviour or anything like that, or an outbreak of any mental health explosions, none of those things that could have been a consequence of freer legal availability of otherwise illicit drugs have come to pass. So you would think that that would have an impact on the way other people in other politicians in other jurisdictions, other states might approach it. But so far there's been no movement.
Good morning, thank you for speaking to us today. As far as you're aware, has there been much precedence with convictions or such about the ceremonial use of plant ceremonies, ayahuasca, San Pedro, in the state or further or whatever, locally, anything? Thank you.
I didn't quite hear that last part. What was the particular?
Just if there's been convictions with the ceremonial use of plant medicines?
Sorry, yes, it was the word ceremonial. Sorry, thank you. No. Again, the ayahuasca kind of thing is illegal because the drugs involved in that ceremonial use are also on that schedule. The schedule runs for about 15 pages. It's long list of all these sorts of chemicals and chemical variants. So the fact that there is a genuine cultural aspect to ceremonial use would be a little bit taken into account in terms of the penalty. So the way a judge or a magistrate would think about that kind of offending, if that was you were charged with taking part in a ayahuasca ceremony, for example, would be to look at your motivation. Are you doing this to make some dollars? Are you trying to rip people off or whatever? Or do you have a genuine belief that this is a legitimate spiritual exercise? And where the magistrate will assess you fell in that sort of line, I suppose in that spectrum, would be part of it. But would really come down to what's your prior offending, first offence, what was the consequence, or maybe not too serious, it depends. Of course, there was the case which is still going through the court, I think, I'm not quite sure if it's finished, where there was a death involved locally a few years ago now. The coroner's been holding hearings in Lismore around that. I'm not sure if it's complete, but there were certainly some suggestions that a very poor outcome on that particular event, and the people involved in the organisation of the event were criticised for, not so much for doing it, although that was terrific in the sense from the legal point of view, but for the lack of response in terms of getting medical attention and so on for the person who was having some difficulty. So that's what the coroner's focus is really on. I haven't seen it, I don't know if it's complete. There might be some recommendations made around that, but I would not expect that the coroner would be making a recommendation to make it legal. I don't think that's part of what they're looking at, so they wouldn't go there.
Hi Steve, thanks for that. Your answer just then did touch on it, but I just wanted a bit of clarification. If you're gifting mushrooms of like over 100 grams compared to exchanging it for cash, is there a difference in the eyes of the law?
Yes and no. Look, lots of legal questions have a yes or no answer. No, it does not make a difference because it's still an act of supply. Supply means giving, selling, sharing. The definition of supply in the legislation even means asking someone to supply to you, which never really gets charged, but it's stupid, really that much. So it's a very, very broad definition. So whether you give something away, give a drug away, or sell it, you're still committing the offence in terms of it being a supply offence. But when it comes to what sort of penalty you should get, if the magistrate's happy that you were not having any financial reward, that you were sort of sharing with friends who had a shared interest in the substance and so on, then that will be looked at much more favourably, or should be looked at much more favourably than if you're doing it for a buck.
It's on. It's a good, hello everyone. To go back to the first question of how do you change the laws, in my country of origin, there was massive civil disobedience. They plugged up the court system so bad for cannabis, the government threw up their hands, changed the legislation, and basically legalized it all around. And there are still other entities there that are selling psilocybin in street shop fronts and are even distributing LSD, and they want you to get arrested. So they can start making cases against those. It's a case of the government knowing better for what's good for you than you know for yourself. And they just don't seem to read facts or get away from the old medical model. And it's just a farce.
I agree, of course. I might take that as a comment. I might just say also, though, that the courts are busy places, and there are a lot of drug offences dealt with in the courts of New South Wales and every other state, not so much in the ACT, I suppose. And most of those offences, though, are possession offences. It's almost, well, I'm not sure of the actual numbers, but there are something like 10, 12,000 people in New South Wales each year convicted of, or charged and convicted, sometimes without a conviction recorded, but found guilty of possession of a drug, a prohibited drug. Almost all of those are cannabis. A very large percentage is cannabis, followed by methamphetamine in the sort of numbers. The number of people charged with supply offences and cultivation offences is there. It's a significant number. That does take up a fair bit of court time as well. But the courts are, in one sense, being overrun already. So I don't know that putting too much pressure on the court is having much influence in terms of changing the government's attitude to whether it's a good idea or not a good idea to continue with the prohibition model.
I don't see any more hands up, so is that concluding the questions? Right, thank you very much, Steve. Excellent,
leave it at that. I'll be around for a little while if someone wants to have a quiet chat. Yeah, come and find me and have a chat. Happy to deal with both people one-on-one, but yeah, for half an hour or thereabouts. Cheers.